Members, good afternoon. We've got a quorum already, so may I now call the meeting to order. A number of information papers have been issued since the last meeting, but they are not supplementary papers. Then items for the next meeting, we've got paper 415/01 and paper 415/02. The next regular meeting of the panel will be held on the 25th of March, Tuesday at 4:30 p.m. The administration has proposed one item for our discussion, which is establishment of an electronic database of Hong Kong legislation with legal status. We've gone through the list of outstanding items for discussion. We propose that members can discuss the common law offense of championship, and also we can also consider discussing compensation for wrongful conviction. So should we discuss these two items next time as well? Members, any comments? So should we discuss these two items as well next time? Thank you. And then we'll now move on to agenda item number 3, mechanism for handling complaints against judicial conduct. In fact, we have been following up on this matter for some time. We last discussed this issue at our meeting on the 23rd of July last year. I think we can now invite the deputations in. We've got paper CB 4415-1314-03, mechanism for handling complaints against judicial conduct. And then we've got paper 415/1314-04, background brief prepared by the Electrical Secretariat on the mechanism for handling complaints against judicial conduct. And then we've got paper CB 4419-1314-01. And this is the speech of Mr. Derry Wong, founder of the Judicial Affairs Concern Movement. And then we've got the written submission from Mr. Barry Chin from the CAHK Legal Exchange Foundation. And it's entitled Judges' Behavior. So members, you can refer to these papers. So on behalf of the AJLS panel, I would like to welcome the deputations. And please note that neither your written nor your verbal submissions to this panel will be covered by the Electoral Powers and Privileges Ordinance. And as the panel's terms of reference are restricted to monitoring and studying the policy issues relating to the administration of justice and legal services, when the deputations speak on the mechanism for handling complaints against judicial conduct, please do not comment on the conduct or behavior of individual judicial officers or judges. Please comment on the mechanism. And if you need to declare any interest, please do so before you speak. I will now invite the deputations to speak. And we hope to give each deputation 5 minutes to address the panel. And then I will invite representatives from the Judiciary Administration to reply. And then members will ask questions. So I think I'll give each member 4 minutes to ask questions and to receive replies. So the deputations are here, and I would now like to invite the first deputation to speak. Mr. Derry Wong, Judicial Affairs Concern Movement. But then Mr. Derry Wong hasn't arrived yet, and so may I invite the Dean of the Faculty of Law, CU Hong Kong, Professor Christopher Gain, to address the panel. Professor Gain, please.
Thank you very much indeed, Chair. We are at slight disadvantage in that we've only just seen this paper here and haven't had the opportunity to review it. Nonetheless, I think the broad principles of the matter that is under discussion just now are probably quite well understood. The question of how one deals with judicial misconduct is something which is viewed as with considerable, as raising matters of considerable sensitivity in most jurisdictions, and it's very important that whatever the procedures adopted look like, they are able to balance the natural and appropriate interests of individuals who feel that a judge at whatever level in a particular case has behaved inappropriately. That needs to be balanced, of course, with the need to maintain appropriate respect for the judicial office. I think that one of the very important questions that needs to be considered here is the extent to which investigation of judicial misconduct is a matter that should be left entirely in the hands of the judiciary, or whether or not it is appropriate to consider mechanisms which allow an appropriate lay involvement in dealing with matters of this kind. That may be regarded by some as perhaps an innovation, and some may actually regard it as being inappropriate. But on the other hand, we need to recognise that judges above a certain level are, of course, appointed by a process which involves lay participation. And my own view is that there is nothing wrong in principle with some lay involvement in the process of reviewing the conduct of individual judges and determining whether or not that conduct conforms to the high standards of judicial behaviour which would be expected in a jurisdiction such as Hong Kong. There are elements of lay participation in other systems outside Hong Kong. I think that when lay participation is included, on the other hand, it needs to be included in a way that allows the individuals concerned to believe that they are exercising some independent input into the system, which is not always achieved in some other jurisdictions. I think also there is an important question about the extent to which processes of investigation can only be based on formal complaint, or whether there are other appropriate ways of allowing concerns about the conduct of particular judicial officers to be raised even in the absence of a formal complaint. Again, provisions that do allow this do exist in systems outside Hong Kong. But overall, the general point I think that needs to be made is that the kinds of complaints that I think are properly under discussion here are matters that are entirely separate from the question of whether or not any individual or group of individuals agrees with the decisions that judges have taken in a given case, or even the pattern of decision making in a given court. Where the concern is about that kind of matter, there are appropriate mechanisms in place for the individuals concerned. In a case, there is always the available routes of appeal. And for those who are not involved in the case but still think that the judges are getting it wrong, then there is, in a sense, there are many opportunities for people to voice those concerns. And if those concerns ultimately are shared and shown to be well-founded, then again, in a system such as Hong Kong, the resolution of those kinds of complaints lies with the legislature. And that's, my opinion, is the appropriate way to deal with these matters. Thank you.
Professor Ging.
Thank you very much, Professor Gain. Next, we have Mr. Paul Shea, Chairman of the Hong Kong Bar Association.
I would speak briefly, and I would then leave it to my colleague, Mr. P.Y. Low, to perhaps supplement on any points that he wishes to add. We have read the administration's paper prepared for the purpose of this hearing. In short, our views are that judicial independence is a very important facet of the system in Hong Kong. And in connection with the point about lay participation in the investigation of complaints against judicial conduct, we agree with the paper put forward by the judiciary. In particular, page 3 at paragraph 8, that because of the need to ensure judicial independence, both in substance and as a matter of perception, and also because of the peculiar constitutional framework in Hong Kong, the provisions of Article 89, we do not believe that it is appropriate that there should be what one calls lay participation in the process of investigation. Now, it could well be said that a system whereby judges, or some have said that the existing system involves judges investigating themselves. But the answer to that is that if institutionally we trust our judges to dispense justice without fear or favor in matters concerning disputes between the state and the people, there is no good reason in principle why we should not trust the same judges to dispense justice without fear or favor when it concerns a complaint against their own. After all, in dealing with appeals, judges are having to pass judgment on the correctness and sometimes the conduct of their learned judicial brothers. But it has never been said that because in hearing an appeal, judges are being called upon to say that their learned brothers are wrong, there should be some kind of lay participation. So it may well be said that other places do things differently, but in the particular context of Hong Kong, we believe that judicial independence, both substantive and perceived, plus the constitutional framework of Hong Kong, go against allowing lay participation. Perhaps I should now pass to P.Y. Low to see whether he has anything to add, subject to the leave of Chairman.
多謝主席。用少少時間嚟講，係提一提咧就。
Thank you, Madam Chair. If I may spend some time to say the following. Indeed, we have the Guide to Judicial Conduct. It was in year 2004 that it was developed by working group recently has been revised. It is a public document, and therefore members of the public can see in order to maintain their professionalism, what sort of conduct is expected of them. And then in the year 2009, during the opening ceremony of the legal year, the CJ mentioned that judges at all levels were aware that they were sort of being seen by others, and they were supposed to maintain a high standard of behavior. Well, when we talk about judicial independence, of course, we have to bear in mind media monitoring. Both are interrelated. Judges at all levels should bear this point in mind. Currently, for the judiciary's proposals, including measures to enhance the transparency and efficiency, I think we do understand such points, and we hope that in future there will be further enhancement in these two aspects. Thank you. Next to speak, Mr. Barry Chin, CHK Legal Exchange Foundation. Well, I think Article 89, among other things, have already been sort of mentioned, and CAP 433 also provides clearly for the procedures involved. But then if the public do not agree with what I've just said, then I think we need to look at the fundamental principles rather than challenging the system and accusing it of being unsatisfactory. Well, the common law and the basic law have already said that other judges can be asked to pass a comment. I'm also a legal practitioner. All I can say is that at most we can ask for a good system. We don't have a perfect system. At common law, I understand that more than 1,000 years ago, during the days of the Roman Empire, the system has started. If you want to introduce a revolutionary change, I don't think it is desirable and it is not realistic. Well, throughout the common law is clear about the independence of the judiciary, including appointments, and also free from interference from the executive. To secure tenure is also important. Well, I think please try to stick to one language. Then it will be easier for the interpreters to interpret between the two languages. Well, for many years, it's been confirmed that the judiciary should be allowed to be independent. It is common sense. It should be free from political interference. It should be free from the interference by the executive. And there is also this idea of immunity. We always have to strike a balance in this human world. And then there is clear authority. There are also case laws that say, for example, in the case of Congo, I think a UK case law, Philippine Admiral, was mentioned. It was made clear that there was no need to consult the views of the executive. There's no need to seek such views of the politicians. Otherwise, the case will become politicized. Otherwise, it will become a matter of political expediency. So the matter is, we have to ask this question, whether the judges are accountable to the society. I think it is very clear that the legal system is such that it doesn't mean that when you have democracy, you can expose everything. When a judge makes a decision, I don't think there should be any influence from the political sphere. Currently, I think there are enough checks and balances. And then if the society suddenly comes up with an expectation as to the decision of a court case, if they are appointed in that regard, they shouldn't go around to protest. Well, it has been said that there should be a greater degree of transparency so as to monitor the complaints against the judges. Of course, I would welcome this. However, if there is too much transparency, then I'm afraid it will be a hindrance, and it means that it is rather like judging the judges themselves. We always have to make strike a balance, and we have to be mindful about the cost to be, the price to be paid. Why should we go into a courtroom and bow to the judge, and why he should have the right to speak first? Well, I think if you are unhappy about the performance of a particular judge, you have a mechanism to complain against him. Barristers are also very capable, and they have professional standards to pass a judgment. In some cases, a judge may seem to be passing down a very heavy sentence. Maybe there are things that he has noted which we haven't observed. Sometimes it's lenient. We can't then just say that he is being too generous. Maybe he has observed certain things that we haven't considered. And sometimes it is said that the tone of a judge's speech may affect the lawyer. But I don't think the comment from a judge would automatically result in a very heavy sentence. I think despite the comments made by a judge, the judge will still pass a impartial judgment. Sometimes a person may be convicted and he may get a sort of reprimand from the judge, but it is justified. Thank you, Mr. Chin. Next, Mr. Wong Ming has just arrived, and he's from the concerned group. So, Mr. Wong, I would like to share a few simple points with you, Madam Chair and members. When it comes to judicial independence, it means that judges can discharge justice without interference, so that social justice can be upheld. The ultimate purpose of having judicial independence is to make sure that we can protect the rule of law rather than protecting the judges themselves. In other words, judicial independence has only got meaning as a tool. It hasn't got its own meaning. If the judicial officers are unethical, and if there isn't any disciplinary action against them, then it will harm the rule of the law. And I think we have to look at two very important conditions. First of all, there must be a code of conduct for judges, and this code of conduct which must be authoritative and binding. And then for this code of conduct, there must be independent and effective enforcement. Now, for a judicial code of conduct, I think it should be legislated so as to uphold its binding effect. If the code of conduct is only to be drafted and enforced by the judiciary itself, then the powers will be over-concentrated and it will become absolute. Within the framework of the basic law, we have to set up an independent mechanism so that all the unethical conduct of the judiciary should be subject to thorough investigation so as to safeguard the interests of the public. Thank you. We still have time left. Do you have anything to add? No? Now, the floor is now open to members for your questions. For the time being, 3 members have indicated their wish to speak. Who else would like to speak? I would suggest that we have 4 minutes for each member for both question and answer. First of all, Mr. Ronnie Tong. Thank you, Madam Chair. For the concept of the rule of law, for the concept of judicial independence, sometimes the public may not have a very good understanding. Let me talk about this. If a judge may make a wrong judgment, and he may also give the impression that he's biased, but I don't think he should be penalized and he shouldn't be removed. Judging a case wrongly or being perceived to be biased, such matters should be redressed by the appellate court. For an independent judiciary, I think we have to make sure that judges won't be affected by the lack of agreement by the majority of the members of the public. I've been in practice for 40 years. I think there were only 3 cases in which there was misconduct on the part of the judges, and then they were asked to resign or they were asked to retire early. In one case, the judge went to Macau to engage in gambling with a party of the case, and they shared the room. So it brought disgrace to the judiciary. And then in that case, the judge was reading a novel. So again, it brought a disgrace to the judiciary. And then in the third case, the judge did not serve in the army, but he claimed to have done so. And so he was not honest about his qualifications. And so he was asked to retire early. So it's got nothing to do with the rightness or wrongness of his judgment of cases. And in fact, for the 3 cases that I've outlined, I think 2 of them were up to the mark, or some had even praised them for being good judges.
So I just want to say that judicial conduct is different from the judgment handed down by the courts. Now, I am supportive of the concept of transparency, but then it doesn't mean that the investigation of all cases must be made open to the public. We just need to tell the Hong Kong public that there is a mechanism for handling complaints against judicial conduct, and the mechanism should be transparent. And also, when the mechanism is triggered, again, there should be transparency so that people know that the mechanism has been triggered. But then, after the mechanism has been triggered, it doesn't mean that the public should be made aware of all the steps, for example, every step of the investigation and the arguments put forward, and so on and so forth. A judge should not be removed simply or solely because of criticisms by members of the public. I've read the letter from Mr. Leung Kwok Hong and Mr. Wong Yok Man. And I don't think their complaint relates to judicial conduct. Now, they may not agree with the judge, and they should have lodged an appeal. And I don't think the judge should be removed because of this complaint. Thank you. Mr. Wong Yok Man. Yes, thank you. Thank you, Chairman. Concerning Mr. Ronnie Tong's comment on our letter, I think Long Hair can talk to him later. I want to talk about the mechanism, because this item is on the mechanism for handling complaints against judicial conduct. I will comment on the mechanism as well. Now, judicial independence is important, but it is important, also very important, that the rule of law can be safeguarded and manifested. The judiciary should set up a sound as well as transparent mechanism to handle complaints against judicial conduct, and there should be monitoring, and one should not use the excuse of judicial independence. And then it is said in paragraph 5A that complaints against judicial decisions should not be dealt with under the mechanism. But then sometimes the conduct of the judge may affect procedural justice, and so I don't think the 2 types of complaints are mutually exclusive. I think the person concerned can decide whether to lodge an appeal, but then I don't think we should jump to the conclusion that judicial decisions must not be dealt with under the mechanism for handling complaints against judicial conduct. As Mr. Paul Chair has pointed out previously, some of the litigants are not legally represented. They may not be able to differentiate between the 2 types of complaints. And so we can't say that judicial independence overrides everything. And then it is said that many of the complaints received are against judicial decisions and not judicial conduct. But then may I refer to the information provided by the judiciary on the 23rd of July 2013. In 2012, 126 complaints were received. 74 were related to judicial decisions, 31 related to judicial conduct, 21 related to both. So in other words, 41.27% of the complaints had to do with complaints about judicial conduct. So you can't conclude here that in fact most of the complaints have to do with judicial decisions and not judicial conduct. And in fact I have a lot to say, but then I understand that I don't have enough time. And then para 8 details the CJ's position, and he has referred to Article 89, and he is of the view that complaints should be handled or handled by judges only. Article 89 is about the removal of judges, but and concerning having a mechanism to deal with complaints against judicial conduct, then if it is discovered that the judge should be removed, then of course the Article 89 procedures can come in. And with regard to the tribunal mentioned, in fact there is, I think, for example, local retired judges or even lay members, I think should be allowed to sit on the tribunal. Judiciary Administrator on the 23rd of July last year agreed that further information will be provided to us to facilitate our discussion, but we haven't got such information. For example, the number of magistrates who have not practiced law prior to their judicial appointments as registrars. Second, the current mechanism for handling complaints against judicial conduct in other jurisdictions. Third, the number of complaint cases that have been brought to the attention of the JOC in the past 3 years and the subsequent actions taken on these cases. Fourth, what constituted misbehavior of a judge as stated in Article 89 of the Basic Law, for which the judge might be removed by the CE in accordance with relevant proceedings prescribed in the Basic Law. And finally, the right, if any, of complainants to access the audio recordings of the court proceedings in connection with their complaints against judges. Thank you. Mr. Wong Yok Man has referred to the information that members sought at the meeting we held in July last year. Mr. Dennis Kwok.
Areas of concern, as expressed by the panel in the last occasion, is whether there should be a more detailed set of procedures in relation to judicial complaints, and whether the existing mechanism is effective in dealing with the cases of complaint. And we note at paragraph 10C of your paper that one of the areas of concern or one of the areas being looked at by the working group is whether the court leader in question has enough capacity or sufficient resources to deal with all the complaints effectively and diligently. And for example, one could imagine that the chief magistrate, for example, being the court leader, who is responsible for the large amount of complaints which the public may have against magistrate decisions and the sheer number of cases that go through the magistrate system. The court leader in question would probably have to spend most of his time, if not all of his time, dealing with complaints from the public. Now, is the current arrangement really is enough or sufficient to allow the court leader to deal with it on his own? Now, if you look at other jurisdictions like the United Kingdom, they have what is called the Judicial Conduct Investigation Office, which assists the Lord Chief Justice in handling complaints. And although the decisions is ultimately made by the judiciary or the relevant nominated judge in question, the investigation work is often done by this office, in pursuant to a prescribed procedures, regulations 2013. So one would wonder whether in Hong Kong we can follow similar procedures and having those procedures set out in the regulations, and to consider the workload which court leaders have to bear in dealing with these complaints.
係司法機構嘅代表有冇回應啊？佢哋
Any response from the JA, please? Now, because there is time left for you to give a response. Mr. Dennis Kwok was given 4 minutes and he didn't use up the 4 minutes. Yes, thank you, Chairman. In December last year, the CJ set up an internal working group comprising the CJ himself as well as 3 court leaders. The working group is going to carry out a comprehensive review of the mechanism for handling complaints against judicial conduct. The mechanism was introduced in 2003. It has been in operation for some time, and the CJ feels that it's high time that the judiciary conducted a review. Under the present mechanism, court leaders at all levels of court deal with complaints against judicial conduct. And as stated in the paper, one of the areas of the review is to see whether resources for court leaders for this purpose are adequate. All right, so do I need to continue? I think I'll ask whether Mr. Dennis Kwok would like to follow up. Chairman, concerning the Chief Magistrate, now he has to deal with all complaints against the judicial conduct of the magistrates. Is that correct? Yes. So let me have 10 seconds more, Chairman. Can you expect one person to be capable of dealing with all the complaints, and there are so many complaints? And I think, are you sure that every time his decision will be credible and acceptable? Chairman, thank you. The Chief Magistrate is assisted by his subordinates in discharging his duties in this regard. Thank you. I just want to remind members they can ask the administration questions or they can ask deputations questions. Yes, Ms. N. Chen. Thank you. I welcome the judiciary's willingness to review the system. Now, please don't feel worried as to why LegCo is so concerned about this mechanism for handling complaints against judicial conduct. I understand that the number of complaints against judicial conduct has increased. This mechanism has been in place for quite some time, and I think a review is needed. As you know, society has been changing and progressing, and I think all organizations in society should also progress with the times. Now, there is a guide to judicial conduct. I want to know what will happen if a judge has found or has been found to have violated the guide. Is it that the CJ will take action? Mr. P.Y. Low or Mr. Lee? So what will happen if there is a breach of the guide to judicial conduct? Now, this is a guide. This is not a code. In 2004, the guide was published by the judiciary. It serves as a useful guide to judges and judicial officers, and we hope that judges and judicial officers can conduct themselves in accordance with the highest standards. But what if there is a breach of the guide? What if a judge has been found to have breached the guide? Concerning the consequences, so to speak. Now, as I've said just now, this is a guide, and so there is no definition for judicial misbehavior, and there are no penalties provided for in the guide. Mr. Low, please. I think Mr. Lee has given a very clear reply to Ms. Chang's question. I've got nothing to add. Ms. Chang. So that's where the problem lies. Say, at the magistracy court or at the district court, the judge and the judge alone makes a decision and hands down a ruling. You know, in Hong Kong, of course, we have the common law, and of course the basic law, and then the common law is practiced. So it's up to the judge to decide whether he believes the evidence or not. Now, say someone has stolen something from a shop. Now, it's not necessary for him to be caught red-handed. Someone will bring the case to court, and then the judge can decide whether to believe in the evidence heard.
Of course, when the defendant is convicted, if he's aggrieved, then of course he can appeal against the decision. Undeniably, for you to lodge an appeal, it is very costly. Moreover, judges have also got the power to say that the defendant, when convicted, should go to jail and serve the sentence while pending the appeal. So I support the idea that we should quickly have a review, and if the outcome is such that it is found to be necessary, it is not that legislators would like to make a judgment as to whether judges have been right or wrong, but I believe that within the judiciary you should set up a mechanism, or you should have a panel so as to assess the performance of the judge who has been complained against. Say, for example, measuring the conduct against the guide to judicial conduct and try to find out whether the judge has already followed all the procedures. And I think that's much better. Otherwise, members of the public have nowhere to turn to. The only option left seems to be to lodge an appeal. I think we still have time, so I've allowed Dr. N. Zhang to finish her remarks since we haven't got too many members waiting to speak. Mr. Leung Kwok Hong, Ronnie Tong talked about my letter co-signed with Mr. Wong Yok Man. We weren't really against the judicial decision. So it's not a matter of appealing against a particular court decision. Of course, for any judicial officers, if in the discharge of the duties, the judge makes a decision, the decision can be overturned. But I don't know why the decision was overturned. But that's not the question. Now, this is very simple. If we talk about an independent judiciary, and if the judges commit a mistake, who's going to address the problem? Currently, we have the CJ, the court leaders, handling the matter. Now, that's the crux of the matter. If he cannot discharge his duty, and then in accordance with Article 89 of the Basic Law, he will handle the cases according to that article. But then it means that the CJ will appoint a tribunal. But then for the person that I complained against, he has now become the CJ. So he's the person who was involved. Within his tenure, he appointed a master to deal with the criminal appeals on his behalf. So I would like to put this question to the barristers and solicitors here. Do we have any procedural justice? At that time, Mr. Jeffrey Ma was the chief judge of the appeal court, and then he was promoted. Now, under Article 89, we have this mechanism. Do you really believe that Jeffrey Ma would appoint another judge to investigate into his conduct? If he will, then I am convinced and I'm satisfied. But the problem is he's not going to appoint another person. Now, I had not wanted to name individuals, but if I don't name names, then people would say that I'm trying to cause trouble. Now, there isn't a mechanism for us to invoke. I have written to the SJ, but Mr. Yun has said that it's not his work. Now, I have one case going to the CFA, and I may be sentenced to serve a jail sentence. And then there was also this case against Mr. Jasper Zhang as to whether I should be allowed to filibuster. So I am not taking the matter lightly because I'm at high risk, because I may be sent to jail, and yet I'm making allegations against him. Now, it is like the question of there is an island and then there is one barber who would be cutting hair for everybody else because he's going to cut the hair for him. Now, if the leader has got the right to look into the investigation, to look into the allegations against all others, but what if he himself is the subject matter of complaint? If we have got the separation of the three powers, then we can hold CY Leung responsible. But in this case, what about the CJ himself? Now, if we try to investigate into his matter under the Powers and Privileges Ordinance, then there will be a constitutional crisis because it's not going to appear before us. Well, Madam Chair, we have been fair. In July, we wrote a letter to ask a question concerning the practice overseas, that is, the mechanisms overseas handling judicial misbehavior. The letter went unanswered. Now 7 months have already passed because we are now in February. Madam Chair, I complained against the current CJ. It looks like that I'm getting a noose to hang myself, but I am going after justice. I'm not joking. In this conference room, I don't think anybody dares to try to do anything like this or try to take the matter lightly, because I am involved in 2 cases for which I may receive a heavy sentence. Mr. Lee. Madam Chair, I was also about to ask about the experience of overseas jurisdictions in handling allegations against judicial misbehavior. It seems that the paper is silent on this part, and just now I have listened to the deputations. I also read the papers. I understand that the rule of law is very important to Hong Kong. Now, it appears to me that we aren't talking about judicial decision. Rather, it's a matter of the misbehavior of judges. Yes, we have got a provision in the basic law, but then overseas experience will be helpful in facilitating our understanding. What about enhancement of transparency? I want to note about the judiciary's consideration. It appears again that the paper hasn't got much to say about this. Mr. Lee. Thank you, Madam Chair. For the judiciary, we are aware of the request for information at the meeting of the AJOS panel held on the 23rd of July. last year. I think they will be taken up together with the review that is currently underway, and then will provide the information in a comprehensive manner. Just now, members referred to the mechanism elsewhere in other jurisdictions. I think we need time to study the matter. In our paper, we have said that we need to be careful, we have to be cautious when we look at the overseas practices, because not all other practices can be sort of adopted in the local context. As to the figures asked for, again, we would like to wait for the completion of the study and then we'll take up the matter together. Just now, members also asked a question about the transparency. Members would like to know what suggestions we have got to enhance the transparency. Well, the review was only started in December. We're still in the stage of analyzing and collating the basic information. So we haven't come to the stage of having specific recommendations to share with you. Mr. Lee, yes, Mr. Lee, I want to know approximately when you can come back with the report. For the experience of overseas jurisdictions, I found it strange for you to say so. I think it isn't anything new. I think we can get the experience from overseas jurisdictions. Can you not sort of give us some ideas briefly? As to the completion of the review, as stated in the paper, we expect to finish it in 1 year's time. So before end of this year, we expect a report. Mr. Lee, other than Mr. Lee, I think within this week, other than panel members, I have received complaints from other non-panel members in relation to your paper, because we are concerned about the figures involved and as well as the overseas practices. So Ms. Lee was also on this point. We want to get a more satisfactory answer. I find it difficult to understand. I don't think it's that difficult to get the information about the overseas experience. I'm a lay person, but then we have got a lot of professionals here. It is not anything new. So you do need a year's time to find out about the overseas practice, right? Mr. Lee, I did not mean that we required a year's time to dig up the information. We need to gather the information and then we have to analyze the information and then we have to come up with recommendations for improvement. Next, Mr. Paul Chair. Madam Chair, I read the paper for paragraph 16. I think the JA agreed to provide the following information after the meeting at the request of the panel. 6 months have already passed since the last meeting. Now the conclusion is that they would like to carry out their own review and it will take a year's time to complete the job. I hope this doesn't reflect the mentality that the judiciary thinks that it is above everything else and we shouldn't intervene and the judiciary has got its own way of doing things. This is too arrogant. You may very well want to carry out your own review and have your own investigations, but once you've agreed to provide the information to us, I cannot see why you would ask us to wait for a year before you give the information to us. And then for Cap 433 concerning the membership of the tribunal, I think as it stands, the CJ, if appropriate, will appoint a tribunal and then 2 High Court judges and a public officer will be appointed. I think probably Mr. Chin has got it wrong. I think he thought it was the CJ plus 2 High Court judges, but that's not the case. I want to know who would be appointed as the 3rd member. What sort of public officers have been appointed to act as the 3rd member? What about fairness? Are you going to appoint a lawmaker? anybody not related to the judiciary to sit on the tribunal. He may not be the majority on the tribunal, but then it will certainly enhance the accountability. Thirdly, Madam Chair, I want to know if you would include the following points in your review. In many cases, litigants are unrepresented. They may find it difficult to distinguish between judicial decisions and judicial conduct. For judicial decisions, if they're not happy, they have to appeal against the decision. And then there are other things which should fall into the category of judicial conduct. So I want to know whether you're going to assist such unrepresented parties so that they can know whether they should appeal or they should complain. Do we have legal aid for them? Mr. Lee, information-wise, it's not that we don't want to give the information to you. It is a fact that after we had attended that meeting, we have to consider how the mechanism should be set up. And in December, sorry, Mr. Lee, we aren't asking for your findings. We just want to get the raw information, so that you can have your analysis. We can also study the matter.
Now, because if you don't provide us with the raw materials, we can't have access. We won't have access to the raw materials. Chairman, we haven't held on to the raw materials without releasing the materials to members. We, of course, will have to liaise with overseas judiciaries, and we, of course, can also search for the information on the internet. But Mr. Lee, may I refer you to para 16 of that paper, in particular C. I think we can't have the information if you don't provide the information to us. Last time, members wanted to have an analysis of the complaint figures, and it takes time to do the analysis because we need to look into all these cases in detail. Now, Mr. Poche is not asking for conclusions. He is asking for figures, for data. I think it would be appropriate if you can provide the data and the information to us. We're not asking you for the conclusions. We just want materials for our reference. There are still members who are queuing up for the first round, and we can, if possible, have a second round. Mr. Martin Liu. I agree with Mr. Ronnie Tong. Now, if there is something wrong with the judicial decision, then of course there is the rectification mechanism, there is the appeal mechanism already there. But then there may be complaints against judicial conduct, the behavior of judges in the courts and outside the courts. For example, allegations like judges getting associated with undesirable elements, judges having been found to have visited some undesirable premises, and so on and so forth. And if judges, because of these, are disciplined, and I don't think that would mean an encroachment on the rule of law. And then, of course, we have Article 89 of the Basic Law. But then Article 89 is about the removal of judges. But there may be cases of judicial conduct or misconduct which do not warrant removal. For example, between reprimand by the CJ and removal by the CE, there may be a range of disciplinary actions in between the two. I welcome the review that is underway. I understand that this review will take about a year's time, so we'll wait for the review report and then we can revisit the subject. But then, and of course, I don't know what the outcome of the review will be, but I want to point out that I hope that the mechanism can become more transparent. And then concerning decisions made under the mechanism, we hope that those decisions will be well justified. Do you want Mr. Lee to respond? He can choose whether he wants to respond or not. All right, we have three members who are queuing up for the second round. And I will make some comments in the first round, and then we'll move on to the second round. Some members have referred to the requests we made in July last year. We sought information from you at our last meeting, and I believe most of the information can be provided by you. For example, the number of complaint cases brought to the attention of the JOC in the past 3 years and the subsequent actions taken, and we want to have such information. And then second, we, of course, want to see improvements to the present mechanism. But of course, we also bear in mind that we must not affect the operation of the judiciary. So what is your position? What is your point of view? We've also asked for the information concerning other jurisdictions. In fact, we've also tried to obtain information from you with regard to legal aid systems in other countries. And you can't expect us to just do a search on the internet. Can you give us a timetable as to when you can provide us with the information, and then we'll decide when we're going to have another discussion. And I've received comments or questions from members of the public and from some lawyers. Lawyers are reluctant to ask these questions in public, so I'm really asking these questions on their behalf. Some lawyers may feel that there may be a certain degree of conflict of interest on the part of the judge presiding over a particular trial. And sometimes the litigants or members of the public also hold the same view, but then they dare not make this point in the court because they are worried that they may make the judge angry. But then, at the same time, they are worried that as they haven't pointed out the conflict of interest, as they haven't applied for the change of the judge, then they may be at a disadvantage. So, can you really clarify your position? Chairman, I am not saying that members should do their research on the internet. What I was trying to say is that we are looking at the arrangements in other jurisdictions. So we are also doing some research on the internet, and we are also seeking clarifications from overseas jurisdictions. And we need to gather the information, tidy up the information before we can provide the information to the panel. This review will last for about a year. We hope to be able to provide comprehensive information to members, including, if possible, our comments and recommendations. And in reply to Ms. Starry Lee, I said that the review started only in December last year. we really need time to consider how much we can do in order to increase transparency. And then if the lawyer or the litigants feel that there may be some conflict of interest on the part of the judge. Now, of course, lawyers and the litigants can refer to D of the Guide to Judicial Conduct concerning disqualification of a judge from the presiding over a certain trial. Right, I think we'll now move on to the second round. Dennis Kwok, Ann Chang, Paul Chair, and Leung Kwok Hong. Right, each member will be given 3 minutes. Chairman, thank you. So we have been given a 4-page paper on the general principles only. And we get the impression that the judiciary is really not adopting a proactive attitude with regard to the review. In fact, we asked for the information in July last year. Several months have lapsed. In fact, it takes you only 5 minutes to give us information about the practices in overseas jurisdictions. In 2012, in Australia, there was a 100-page report analyzing the arrangements in 6 common law jurisdictions. Or in 6 jurisdictions rather, including Canada, Australia, the UK. So the report is already there. The Australian report is already there, unless you're telling me that you don't trust their report. So is it that we'll have to wait for another year for you to give us the information? So we can't help getting the impression that the judiciary is not really very enthusiastic and proactive about this review. Now look at common law jurisdictions worldwide, and you can see that in Hong Kong, our mechanism in dealing with complaints against judicial conduct is less open and less transparent, and so there is really room for improvement with regard to this present mechanism. And let me say something about the separation of powers. It is important that the executive respects the judiciary. Now, when judges are sworn in before the CE, they have to wear the all the attire, the robes and so on and so forth. But then is it that the CE has recently said that such formalities are no longer necessary? Is it that the CE has told the judiciary either directly or indirectly that judges do not need to be in the whole set of attire in when they are sworn in before the CE? So I want the judiciary to give me a written reply on this one. Mr. Lee, I'm afraid I'll have to provide the reply in writing. Ms. Ann Chang. Now, of course, the judiciary always honors its promise, right? Last time, you agreed to provide us with certain information. These are the 5 points that we've listed in our background brief. But then we haven't been given the information. So you haven't kept your promise. I hope that you can give us the information that we've asked for as soon as possible. You said that you wanted to seek information on overseas jurisdictions, and then you needed to analyze the information first before the analysis was given to us. Now, no need. You give us the information, we can do the analysis ourselves, and if we have doubts, we can seek your advice. So, Chairman, let's continue to press them for the information. And I want one more item of information, that guide to judicial conduct. Can you give us a copy of the guide? This is an open document, right? So can you give us a copy of the guide so that I won't have to search for it on the internet? Ms. Lee, in fact, I want to clarify, this is a guide, this is not a code. And in fact, the guide is available on the judiciary's website. But of course, if members want a copy, I can send a copy to the Secretariat. Last time, members requested some information. We will follow up. It is not that we won't follow up. We will follow up. Having heard members' views today, we will reflect the views to the CJ. All right, thank you.
All right, thank you for promising to follow up. Other than the guide, I am asking for one more thing. You have said that you have already set up an internal working group to review the relevant mechanism. I welcome this move, but please give us a timetable as to when you're going to complete the task and what is the progress. Now, it is a request from a panel of the Legislative Council. Mr. Lee. Thank you, Madam Chair. For the timetable, well, in fact, we have already set out in the paper. We need a year's time to finish the task. We expect to finish the entire review towards the end of 2014. Next, Paul Chair. Madam Chair, let me once again repeat that I hope the relevant authority, in particular Mr. Lee, can follow up on the various items in paragraph 16 of our background brief. I want to know which is available anytime and which has to wait for the completion of your study, because we are actually talking about raw materials, and then I think you can provide the information to us, and then we can also have our own research. Now, for the participation of public officers in the tribunals, according to your record, I want to know who were invited to sit on the tribunals, and I want to know whether we've got anybody commanding high respect and were not judicial officers. And what about unrepresented litigants? Do you have anything to help them to distinguish between judicial decisions which could be appealed against and what would constitute judicial conduct against which they can complain? Mr. Lee, for the first one, I haven't got the information. I need to go back to check the information before I can tell Mr. Chair. For unrepresented litigants, we don't actually have a mechanism to help them to distinguish between a matter that should be appellable or whether it is a matter that should be the subject matter of complaint. Of course, the Home Affairs Bureau did set up a center, but then that's to help the unrepresented litigants in coming to understand the procedures in a court. Do you have anything similar to what we have got in the police stations? I think and even for the ICC, I think they have got something in writing so that the defendants or persons involved will have an understanding about their rights, so that if they are aggrieved, they know which channel they can resort to for appeals or complaints. So if you haven't got something similar, are you going to remedy the situation immediately? Mr. Lee. In relation to complaints against judicial conduct, well, in fact, in the year 2003, when we set up the mechanism, we had a leaflet for the members of the public. The leaflet is being updated all the time. If anybody is interested to have a copy, I'm sure they can come to the judiciary to get a copy. What about something similar to the mechanism when visitors come to Hong Kong and then at the point of entry we give them some information? Well, I think they can visit the resource center for unrepresented litigants, and I'm sure they can get hold of copies of this leaflet. Next, Mr. Leung Kwok Hong. Madam Chair, I don't think the problem has been resolved. Now, for paragraph 8 of the paper from the judiciary, we've been told about the views of the CJ. In the case of a complaint, it is said that they can invoke Article 89 of the Basic Law. But then that's when a judge has been found to have committed misbehavior, and then the CJ will convene a tribunal to see whether the judge should be removed. But now we aren't asking for direct removal. Now a CJ has asked a recorder or a master to look at the criminal appeals for him. So it's a matter of investigation. Now, maybe it's dereliction of duty, it may be misbehavior, it may be injustice procedurally. They are different. So for paragraph 8 of the paper, it talks about the CJ's power. I think this is not the answer we are asking to get. We want to know whether there should be a mechanism with non-judicial officers participating in the work. Now, I come back to my point. For paragraph 8A, 16A, the number of magistrates who had not practiced law prior to their judicial appointments as magistrates. I think it is a matter of whether we can have justice, because if somebody hasn't even practiced law, then how can he become a judge? So our questions have been very specific, our requests are very specific. Again, for paragraph 16B, and then for 16C, again, you haven't given us the information. We want to know about the nature of the complaints. We want to know whether the complaints are for both reasons. First, wrong decisions. Second, misbehavior. Now, it seems that you give me a gun, you yourself have a gun, but you don't give me the bullets. Now, if we are to have a sort of a fight, if we are supposed to shoot at each other, but if I haven't got any bullets in my gun, then I'm at a disadvantage. Now, if you don't have an affirmation, if your submission is wrong, is poorly written, then you don't get leave to appeal. On 2 occasions, despite having written for 10,000 words, you have turned down my application to have judicial review. So, if you had been in my position, you would not even have been allowed entry into this conference room. Mr. Leung's point is clear. Now, one more member would like to speak for the 3rd time. Ms. Terry Lee would also like to speak for a 2nd time. So Terry first, and then 3 minutes, please. Ms. Terry Lee. Madam Chair, I have a request. No, the administration hasn't been able to give us the information. So members are not happy, so I would suggest that we keep it in view and have it included in the list of outstanding issues. When we get information from them, then I think we can reopen the discussion. For paragraph 8 of the paper, the CJ considers it important to stress that the review must be conducted on a premise having regard to the following principles. For subparagraph C, I have yet to be convinced. I tried to read Article 89 of the Basic Law again. As members have pointed out, the scope of application is that when a judge is unable to discharge his or her duties or is because of misbehavior, then the CJ may appoint a tribunal making up of no fewer than 3 local judges. But can we then take it to mean that even for misbehavior allegations, we can only have a panel made up of judges only? I don't think I have been convinced. I want to know whether you must abide by such a principle. The Legislative Council and also the community at large have already queried as to whether you can only interpret the requirement in this way. Are you going to address this point in your review? Mr. Lee. Paragraph 8 of our paper. It says that the review must be conducted on the premise having regard to the following principles. And then in HC, we say that in taking forward the review, it is important for the direction review to be consistent with the framework as enshrined in the Basic Law, Article 89. This is one of the 3 important principles, and we will take into account, I will follow this principle in our review. I'm a layperson. I don't know whether my understanding is correct or not. I'm sure there must be something in between. Now, for professionals, when a professional is being complained against, then professional bodies would hold hearings or would handle the complaint. I cannot think of any professional body that doesn't allow for laypersons to take part. Now, for Article 89, if you say that that would also cover the investigations and then no other input can be allowed, then it means that it's very different from the procedures pertaining to other professional bodies. Mr. Lee. Thank you, Madam Chair. Of course, when you read paragraph HC, you can't read it out of context, and we have to read HB together. And the CJ has also regarded it as one of the very important principles as well. That is separation of roles and responsibilities among the executive, legislative, and judicial arms of government in dealing with their respective internal affairs. I think when we address this topic, we have to take the 3 principles together. Mr. Lee, I think you must have heard what we are saying. For Article 89, it says that the CE, on the recommendation of a tribunal appointed by the CJ, and consisting of not fewer than 3 local judges. It's a matter of whether we should be restricted by judges only. But it says not fewer than 3 local judges. It means that the minimum will be 3 local judges. And in the case of the CJ of the CFA, then no fewer than 5 local judges. Now, a lot has been said as to whether only judges can look into the matter, and will that mean that we lack somebody who is impartial? For the 3rd round, we have Dr. N. Jen and then Mr. Dennis Kwok. And then we have to draw a line and we have to close the session for members' questions. And then at the end of the day, I will just check with the deputations if they have got anything to add. Mr. Lan Kwok Hong? All right, 3 of you, 1 minute each. N. Jen. Make a quick point. I'll try to let you finish with your point. Chair, last time at the panel meeting, some members suggested that we should set up an independent investigatory mechanism. The CJ has come back with an answer to say that he opposes it, saying that this will it will affect the independence of the judiciary. Well, let us pass this message to the CJ. Well, you can't just go after independence. You have to be open, you have to be transparent, and then you can command the respect. What is important is that people respect the judiciary, our rule of law. So please also tell the judiciary the following. Now, with Mr. Lee here, he's trying his best to answer our questions, but he is the deputy JA. Maybe there are 5 or 6 other deputy JAs. Who is the JA? Ms. M. Lau. Why don't we ask Ms. Lau, who can make decisions, to come? Now, you are coming very soon to get money, and you will be increasing the judicial pay and at a rate higher than others. Now, a number of requests have been made to ask for information, but we can't get it. I have sympathy for you. I don't think anybody would say that we are being excessive in asking for the information, like the number of complaints, etc. It's no big deal. So maybe Mr. Lee has some difficulties that he hasn't told us. So maybe we get the JA to come.
Mr. Dennis Kwok. Chairman, I've just got a simple question and hope that the Bar Association can try to answer the question. Mr. Darley asked a question about whether the tribunal should only comprise judges. Is it that the Bar Association is of the view that there shouldn't be laypersons taking part in the mechanism? So can you please reply? You have 30 seconds. Mr. Shea, the chairman of the Bar Association. If you look at Article 89, it says not fewer than how many judges. In fact, Mr. Low has written a book on the basic law. Mr. P.Y. Low has written a book on the basic law, and in fact, he has pointed out. Please continue. Article 89 doesn't say that apart from the 3 local judges or the 5 local judges, whether we can get retired judges or laypersons to sit on the tribunal. So you can argue both ways. But I have just pointed out that one bone of contention or one point of controversy may be this. If you are saying not fewer than 3 local judges, but at the same time there can be many non-local judges and there can be many lay members of the public, will that go against the original spirit? Of course, this is an issue of, or that may be an issue of controversy. And I believe that may be one of the arguments that the CJ has in mind in making the point under para 8C, because the basic law doesn't say whether the tribunal can only comprise judges. So I just want to say that at least my understanding is that if you say not fewer than 3 judges, not fewer than 5 local judges, and then there may be 200 lay members, then what's going to happen? So I was just looking at this issue. We may not be able to go into details as to the numbers, but Mr. Lee, members are just asking whether there can be room to introduce lay participation. Mr. Leung Kwok Hong, I think the CJ's position is extremely clear. He is of the view that the tribunal should comprise judges and judges only. In fact, I respect the separation of powers, and I don't think the executive and the legislature should be allowed to interfere with the judicial arm. But then can we allow the fourth power to come in here? Now, say I wanted to appeal, I wanted to have the audio recordings, and I had to pay several tens of thousands of dollars. And if the mass media have to pay this amount in order to get the the audio recordings, how can the mass media monitor play its monitoring role effectively? So I think you have to facilitate the media's monitoring what you do. What if there is someone who cannot be monitored or is not monitored? Now, in fact, judges are also human beings. Absolute power may bring absolute corruption. This is what was said by a House of the Lords. Ms. N. Chang, all right, the last remark. So we haven't been given the information, and some members are of the view that we should put this on the list of outstanding items for discussion. Chairman, I suggest that we follow up on this matter next time. Right, your point is noted. We'll deal with this towards the end of the meeting. And now, finally, I'll invite Mr. Lee and the deputations to supplement. Right, the professors, Mr. Lee and Professor Gain.
Chair, one or two very brief observations. I think the first problem is an overemphasis on the role and the place of Article 89. Article 89, in terms, is actually dealing with the situation where you are just contemplating removing a judge from office. Now, a great many issues of judicial misconduct or judicial conduct will not involve any question or any possibility of the judge being removed from office. And I think that needs to be borne in mind, that there may well be areas of complaint about judicial behaviour and judicial conduct which would not result in their removal from office, which is the focus of Article 89. I think the point that lay people need some guidance as to what can and cannot be dealt with under these the existing procedures is very well made. It isn't actually a very difficult form of guidance to be offered. It's available on the websites of other systems that handle complaints about judicial misconduct. It's often difficult to say what is included, but it's not too difficult to state very clearly what cannot be dealt with under a system of complaints about judicial misconduct. And I think that while one always needs to be very careful about making comparisons and drawing lessons from other jurisdictions, I think that there is really quite a lot of information already out there that is available and can be used fairly quickly to reach some of the questions that have been answered by members here this afternoon. Thank you.
係，多謝Professor Gain。咁我諗咧就
Thank you, Professor Gain. Right, Mr. Lee, do you have anything to add? No? Then let's see how we should take the matter forward. Members are of the view that the information should be given to us as soon as possible. We shouldn't be asked to wait for a year. In fact, we made the request in July last year, and a member has suggested that we should discuss this matter again next time. Now, we've decided what items we'll discuss in March, and I think I'll put this issue on the list of outstanding items, and I think perhaps we can revisit the issue in April. And I hope that in the interim, you can give the raw materials to us, and then we will have a meeting. We hope that the Judiciary Administrator can come to answer our questions. But I think what is most important is that you should provide us with the information that we sought in July last year, and I hope that will not be denied the information, and as a result our Secretariat will have to do its own research. So please pass this request to the JA. We've already fixed the agenda for the March meeting, and so I think we'll be able to revisit this matter in April, the earliest. I think we can now conclude the discussion of this item. We thank the deputations for coming today, and we'll now move on to the next item on our agenda.
Next
item on the agenda. Proposed legislative amendments relating to the adjudication of equal opportunities claims in the district court. We've got paper CB4 415/05. Paper from the administration on the proposed legislative amendments relating to the adjudication of equal opportunities claims in the district court. And then we've got paper CB4 415/06, the Law Society's submission. And then we have paper 415/07, submission of the Hong Kong Bar Association. In fact, we've invited all members of this council to take part in a discussion of this matter. So can I invite Mr. Lee to take us through the paper now? Thank you. Thank you, Chairman. The objective of this exercise is to simplify the procedures in relation to the adjudication of equal opportunities claims. Now, at the moment, there are 4 ordinances which come into this exercise. And then under the present system, there is a pleadings system, and with the amendments, then there can be these pleadings can be replaced by simpler claim forms and response forms. The court, of course, when necessary, can order that pleadings be submitted. And we will simplify all the procedures. During the consultation exercise, the EOC, the Bar Association, and the Law Society were consulted. They are generally supportive of the proposed legislative amendments. In fact, there is a marked up copy showing the proposed amendments to the rules. If we can, subject to members' agreement, table the rules or the amendment rules in this council for negative vetting. All right, does any other member or any member wish to speak? Right, we have the Bar Association here with us. Chairman, thank you. We gave a submission to the panel in October 2013. We support the amendments because the amendments will help to simplify the procedures and will help to lower litigation costs. And so because of time constraint, that's all I want to say unless members have got questions for us. Mr. Ronnie Tong, as we only have one member who wishes to speak, I'll give him 5 minutes. I don't need so much time, Chairman. I don't want to take up too much of members' time. I've read the amendments. They are technical amendments, and there aren't too many issues relating to the principles. Now, as there will be a subcommittee set up to scrutinize the rules, I think that I'll leave the details to the subcommittee. All right, other members? All right, let me ask a question. It's good that you're seeking to simplify the procedures. The court can extend the time limit. The court can also, if necessary, require a pleadings. Pleadings to be submitted. I just want to know whether there will be clear guidelines as to when pleadings will be required. Is it really sufficient to say that everything will depend on the discretion of the court? But there will be practice directions so that those concerned will understand the simplified procedures. And of course, we'll be seeking the views of the Law Society and the Bar Association again. So all parties should understand the simplified procedures. But ultimately, it's for the judge to exercise his discretion to decide whether pleadings are required or not. But we believe that pleadings will only be required in exceptional circumstances. We hope that with the amendments, then the claims can be dealt with more speedily. Yes, of course, it's good that procedures are streamlined for the benefit of the public. But then the judge can exercise his discretion, and he may decide in a particular case to require that pleadings be submitted. And I think there should be more transparency. For example, under certain circumstances, the judge will require that pleadings be submitted. So I don't think it's really desirable to say that everything depends on the discretion of the judge. Let me supplement with regard to equal opportunities claims. In some cases, if only forms are filled in, that it will be rather difficult to define the scope, and as a result, litigants will have to spend more time on the case, and as a result, the litigation costs will be higher. So one of the factors to be taken into account is the complexity of the case. If it's a very special case, very complex case, then the judge may feel that pleadings will be preferable because the scope can be well defined, and that will facilitate future interlocutory procedures. And so the judge will take into account the time required for the proceedings and also the cost implications.
So we are concerned not just about the first step, we will also look at the entire flow of the steps. I think the points are clear. I think you were exactly trying to deal with the points of concern to me. I hope that nobody would feel that there is no consistency. That is, for case A, pleadings are required, while for case B, it was the same, it has not been asked for. So I hope that you have guidelines so that things are clear. And then there will be predictability so that one can foretell whether it is a complicated case, and it is quite likely that the court would ask for pleadings so that one can have an idea in advance. So I just want to make the suggestion to you. Thank you. All right. Any other views? If not, then I would also like to ask members the following. That is, whether we support the administration's referral or submission of the bill to the LegCo. All right, we support the submission of this bill. If there aren't other items, then the meeting is adjourned. I would like to thank the representatives from the judiciary as well as the representatives from the Bar Association for staying until the end of the meeting. We have our next meeting in March 25th, 4:30.